All right, part two for week two, talk about some legal, ethical, and professional issues in information security. Basic learning objectives describe the function of and the relationship among laws, regulations, professional organizations, differentiate between laws and ethics, identify major national laws, and then explain the role of culture as it applies to ethics in information security. As a information security professional, it's vital that you understand the scope of an organization's legal and ethical responsibilities to minimize liability and reduce risk from electronic physical threats, loss from legal action. Practitioners must understand the current legal environment, stay current with new laws and regulations that emerge, and watch for issues that need attention. Basic definitions. As individuals, we elect to trade some aspects of personal freedom for social order. Laws are rules that are adopted for determining expected behavior in modern society and are drawn from ethics, which define socially acceptable behavior. Ethics, in turn, is based upon cultural mores, fixed moral attitudes, or customs of a particular group. Some ethics are recognized as universal among cultures. Liability, restitution, due care, due diligence are all discussed in your reading. I put up here some basic summary of how I would define them for your review. And then jurisdiction is another area that you need to be concerned with, especially as it relates to internet-based activity. And then this concept of long-arm jurisdiction, which, again, here's the definition, and you should be able to pluck it from your reading as well. Policy versus law. Obviously, policies are expectations of acceptable behavior within the workplace. Policies function as laws within the organization, but obviously they're not applicable to anyone outside that organization. And to differentiate between policy and law, ignorance of policy is an acceptable defense. So that's one of the issues that we struggle with in information security is how do we make sure that we can hold employees accountable for any policy, and the first step is really making sure that everybody gets it. So if we break that down for criteria for policy enforcement, we look at the dissemination or the distribution of that said policy, making sure that that policy is being reviewed by everybody within the organization, make sure that they understand it, particularly important if we're talking about a multicultural or multinational organization, making sure that we have some acknowledgement that they will comply with that particular policy, and then a mechanism in place to ensure some universal enforcement. Civil law obviously represents a wide variety of laws that are recorded in volumes and volumes of legal code, which is available for review by anyone who wishes to see them. Criminal law addresses violations harmful to society and are actively enforced through prosecution by the state or the federal government. Tort law allows for individuals to seek recourse against others in the event of personal, physical, or financial injury. Private law regulates the relationships between individuals and the organization, and also encompasses things like family law, commercial law, labor law. And then public law regulates the structure and the administration of government agencies and their relationship with citizens, employees, and so forth. And, IRS regulations are a good example of public law, but also things like criminal law, administrative law, constitutional law as well. So let's look at some relevant laws. Obviously the United States has been a leader in the development and implementation of information security legislation. This has allowed for a more reliable business environment, stable economy, And it also demonstrates an understanding of the problems facing the information security field that has specified penalties for individuals and organizations that fail to follow the requirements set forth in U.S. civil statutes. The first one that we can look at is the Computer Fraud and Abuse Act, which is really the cornerstone of many computer-related federal laws and enforcement efforts. It was amended in 1996, in October of 1996, with the National Information Infrastructure Protection Act of 1996, which modified, many sections of the Computer Fraud and Abuse Act and increased the penalties for selected crimes. U.S. Patriot Act of 2001 modified a wide range of existing laws and provided law enforcement agencies with broader latitudes of action to combat terrorism-related activities. The Communications Act of 1934 was revised by the Telecommunications and Compensation Act of 1996, which attempted to modernize the archaic terminology of the Communications Act of 1934. We had also, in this time frame, we had an updated terminology included as part of the Communication Decency Act. The Communication Decency Act was an attempt to regulate, pornography over the internet. Obviously, that got ensnared in a legal debate over an attempt to define indecency, and it was rejected by the Supreme Court. Another key law that's critical importance for the information security profession is the Computer Security Act of 1987. It was one of the first attempts to protect federal computer systems by establishing minimal acceptable security practices. The National Bureau of Standards, in cooperation with the National Security Agency, became responsible for developing these security standards and guidelines. One of the hottest topics that right now is and continues to be is privacy and the ability to collect information on individuals, combine facts from separate sources, and merge it with other information has resulted in large databases of information that were previously impossible to establish. So the aggregation of data from multiple sources permits unethical organizations to build databases of facts with some frightening capabilities. U.S. regulations that we should be familiar with. The Privacy of Customer Information section of the Common Carrier Regulation specifies that any proprietary information shall be used explicitly for providing services and not for marketing purposes. It also stipulates that carriers cannot disclose this information except for when necessary to provide their services. The only other exception is when customer requests the disclosure of information, and then the disclosure is restricted to the customer's information only. The Federal Privacy Act of 1974 regulates the government and the protection of individual privacy and was created to ensure that government agencies protect the privacy of individuals and business information, and to hold those agencies responsible if any portion of this information is released without permission. The Electronic Communications Privacy Act of 1986 regulates the intersection of wire, electronic, and oral communications. The ECPA works in conjunction with the Fourth Amendment of the Constitution, which provides protections from unlawful search and seizure. Health Insurance Portability and Accountability Act of 1996, commonly referred to as HIPAA, also known as the Kennedy-Kassebaum Act, and impacts all healthcare organizations, including small doctor practices, health clinics, life insurers, and colleges and universities, as well as some organizations which have self-insured employee health programs. The Act requires the organizations, any organization that retains healthcare information, to use information system mechanisms to protect this information, as well as policies and procedures to maintain security. It also requires a comprehensive assessment of the organization's information security controls. And then Financial Service Modernization Act, or Gramm-Leach-Bliley Act, 1999, really discuss how organizations can share information among its sub companies or business partners, and it also provides for the opportunity for consumers to opt out. Identity theft. Great information defines it as occurring when someone uses personally identifiable information like your name, social security number, credit card number without your permission to commit fraud. And then if we look at Title 18 U.S. Code, Section 1028, fraud and related activity in connection with identification documents, authentication features, and information. And many states have identity theft regulations as well. You suspect or someone suspects identity theft, obviously you would want to have them reported to 3 dominant consumer reporting agencies, close compromised accounts, dispute accounts with open without permission, and then register your complaint or register a complaint with the FTC. They are the go-to agency for federal agencies to report for consumers to report suspicious activity relating to identity theft through, and you report it also to your local police in the location and police in the location where the identity theft occurred. If we look at Health Insurance Portability Act, again, protects confidentiality and security of healthcare data by putting in place some standards and by standardizing electronic data interchange. Consumers control the medical information that establishes boundaries on the use of that medical information, puts in place some accountability for the privacy, and then it balances public responsibility for the use of medical information for the greater good measured against the impact of the individual. And it's really concerned specifically with healthcare information. In an attempt to protect American ingenuity, intellectual property, and competitive advantage, Congress passed the Economic Espionage Act in 1996. This law was an attempt to prevent trade secrets from being illegally shared. And then we have the Security and Freedom Through Encryption Act of 1997, was an attempt by Congress to provide guidance on the use of encryption and to provide measures for public protection of government intervention. Intellectual property is recognized as a protected asset in the U.S. U.S. copyright law extends this right to published word, including electronic formats. Fair use of copyrighted material includes the use to support news reporting, teaching, scholarship, and a number of other related permissions, so long as the purpose of the use is for educational or library purposes, not for profit and not in excess. I mentioned Sarbanes-Oxley Act of 2002. This affects management of publicly traded corporations and public accounting firms, and it really was an attempt to improve the reliability and accuracy of financial reporting, as well as increase corporate governance. And there were some penalties that are associated with noncompliance, and it was really directed at reliability assurance, requiring additional emphasis on confidentiality and integrity. And it also had built-in fraud controls. And we bring that up here because with financial reporting in today's environment, it's heavily dependent upon technology, which makes information security a natural tie-in as it relates to Sarbanes-Oxley. The Freedom of Information Act provides any person the right to request access to federal agency records or information not determined to be a matter of national security. U.S. government agencies are required to disclose any requested information on receipt of a written request. There are some exceptions for information that are protected from disclosure, and the Act does not apply to state or local government agencies or private businesses or individuals, although many states have their own version of the Freedom of Information Act. In addition to national and international restrictions placed on organizations, the use of computer technology, each state and then some localities have a number of laws and regulations that impact operations. It's the responsibility generally of the information security professional to understand state and laws and regulations and ensure that the organization's policies and procedures comply with those regulations. If we look at some international laws and legal bodies, particularly of interest to any organization that's doing business over the internet, you have to be sensitive to laws and values of different cultures and societies and countries that you may be operating in. And because of different political complexities among these different nations, we find that there are a few international laws relating to privacy and information security, but they are important in that they are limited in their enforceability. Look at the recent the Council of European the Council of Europe drafted the European Council Cybercrime Convention, designed to create an international task force to oversee a range of security functions associated with internet activities and to standardize technology laws across international borders. It also attempts to improve the effectiveness of international investigations into breaches in technology law. This convention was well received by advocates of intellectual property rights, with its emphasis on copyright infringement prosecution. World Trade Organization created the Agreement on Trade Regulated Aspects of Intellectual Property Rights. It was really the first significant international effort to protect intellectual property rights, and outlines requirements of government oversight legislation providing minimum levels of protection for intellectual property. Agreement on Trade Related Aspects of Intellectual Property continued, covers 5 basic areas: basic principles of trading systems, adequate protection for intellectual property, enforcements of those rights by countries in their own territories, and settling intellectual property disputes, and then transitional agreements while new systems are being introduced. Digital Millennium Copyright Act, I mentioned it previously, is the U.S. version of an international effort to reduce the impact of copyright, trademark, and privacy infringement, especially through the removal of technological copyright protection measures. The European Union also put forward Directive 9546 EC that increases protection of individuals with regard to the processing of personal data and the free movement of such data. And you'll notice, if you do any reading about international privacy, Europe is far more sensitive to personal privacy than we are here in the United States. And it's clear in a lot of the standards that are written, as well as the regulations. The United Kingdom has already implemented a version of the directive called the Database Right. Let's take a look at some ethics and information security. Obviously, many professional groups have very explicit rules on ethical behavior. IT and IT security do not have any binding codes of ethics, but you find that if you belong to particular organizations or professional associations, that they do have professional codes of conduct. Sometimes they use them to ban violators from practices in the field, and sometimes it's just kind of kicking you out of the club if you don't conform. One of the struggles that we have are cultural differences with regard to computer use. Differences in computer culture, or differences in culture, cause problems in determining what is ethical and what is not ethical. Studies of ethical sensitivity to computer use reveal that individuals of different nationalities have different perspectives on ethics, and then difficulties arise when one nationality's ethical behavior contradicts that of another national group. Employees must be trained and aware in a number of topics related to information security, not the least of which is the expected behaviors of ethical employees. This is especially important in areas of information security, as many employees may not have formal technical training to understand that their behavior is unethical or even illegal. Proper ethical and legal training is vital to creating an informed, well-prepared, low-risk system user. Deterrence is probably the best method for preventing an illegal or unethical behavior. Laws, policies, and technical controls are all examples of those deterrents. However, it's generally agreed that laws and policies and their associated penalties only deter if 3 conditions are present. First, there has to be a fear of penalty, probability and likelihood of being caught, and then the probability of the penalty being administered. And this is just straight out of any criminological theory. That's basically the way it works. Deterrent only effective if there's a chance of being caught, likelihood of being penalized, and the penalty is severe enough to cause concern for the individual that's considering committing the harm. A number of professional organizations have established codes of conduct that members are expected to follow. Codes of ethics can be positive effect on judgment regarding computer use. Unfortunately, having a code of ethics is not enough because many employers do not encourage their employees to join these professional organizations. It's the responsibility of the security professional to act ethically and according to the policies and procedures of their employer, their professional organization, and the laws of society. Specific ones that we can look at, the Association of Computing Machinery is a respected professional society established in 1947 as the world's first educational and scientific computing society. Its code of ethics requires members to perform their duties in a manner befitting an ethical computing professional. The code contains specific references to protecting the confidentiality of information, causing no harm, protecting the privacy of others, and respecting the intellectual property and copyrights of others. The ISE squared, the International Information System Security Certification Consortium, is a nonprofit organization focusing on the development and implementation of information security certifications and credentials. Their code of ethics puts forth is primarily designed for information security professionals who have earned the certification from IC2. This code focuses on 4 mandatory canons: protect society, the commonwealth, and the infrastructure, act honorably, honestly, justly, responsibly, and legally, provide diligent and competent services to principals, and advance and protect the profession. The System Administration Network and Security Institute, sometimes referred to as SANS, is a professional organization with large membership dedicated to the protection of information systems. They offer sets of certificates called Global Information Assurance Certificates, or GIAC. They too have a set of standards that their organizations must follow, or their constituents must follow. Information Systems Audit and Control Association is a professional organization with a focus on auditing, control, and security. It does not focus exclusively on information security. It does have the Certified Information Systems Auditor certification that does contain many information security components. It also has a Certified Information Systems Manager, Certified Information Systems Risk Administrator, but it has a code of ethics for professionals, and it requires many of the same high standards for ethical performance as other organizations and certifications. Looking at the Information Systems Security Association, it's a nonprofit society of professionals. Primary mission is to bring together qualified practitioners for information exchange. It promotes codes similar to ISC2, Information System Audit and Control Association, and the ACM. Key federal agencies that you should be familiar with: the Federal Bureau of Investigations, established in 1998, serves as the U.S. government's focal point for threat assessment, warning, investigation, responses for threats and attacks against critical U.S. infrastructure. A key part of those efforts is to educate, train, inform, and involve businesses and public sector in information security. Is the National InfraGard program. It was established in 2001, and it began as a cooperative effort between the FBI's Cleveland field office and local technology professionals. Other key federal agencies include the National Security Agency. National Security Agency is responsible for the nation's cryptological organization that coordinates, directs, and performs highly specialized activities to protect U.S. information systems and produce foreign intelligence information. It is also responsible for signal intelligence and information system security. The U.S. Secret Service is a department within the Department of Treasury. It is also charged with the detection and arrest of persons committing U.S. federal offenses related to computer fraud and false identification charges. This represents, an extension of the original mission of protecting U.S. currency-related issues to areas of communication fraud and abuse. Well, in summary, if we look at laws are rules that mandate or prohibit certain behavior in society. These are drawn from ethics. Ethics defines socially acceptable behaviors based on cultural mores, and then the types of laws that we should be familiar with are civil, criminal, private, and public. relevant U.S. laws, the Computer Fraud and Abuse Act, National Information Infrastructure Protection Act of 1996, the Patriot Act of 2001, and the Improvement and Reauthorization Act of the U.S. Patriot Act, Computer Security Act 1987, Title 18, Section 1028. And then, many organizations have codes of conduct and/or codes of ethics. Organizations increase liability if it refuses to take measures known as due care. And due care requires due diligence, requires that organizations make a valid effort to protect others and continually maintain that effort. That is the end of that section. Thank you.